Hi, my name is Suzanna Harvey and I'm one of the partners in the International Private Client team at Burgess Salmon. I'm joined today by one of my fellow partners, Catherine de Maid, and we're discussing issues that clients should consider when contemplating a move to the UK. Today our focus is going to be on South African clients, and that's because Catherine worked in South Africa for many years before returning to the UK about 4 years ago. Therefore, Catherine is uniquely placed to talk about the key issues that clients relocating from South Africa should consider. So, Kath, if I can start by talking to you about the key concepts that we all refer to. Obviously, when we're advising clients from a UK tax perspective and we're considering their exposure to UK tax, we focus very much on our concepts of residence and domicile. But I understand in South Africa there are concepts of tax and exchange control residence. And I wondered if you could just briefly explain how those concepts relate to our concepts of residence and domicile.
Yes, of course. Thanks, Susanna. So exchange control is easy. We don't have exchange control, so there's not an equivalent UK concept. A big part of the decisions for South Africans who are moving here is whether or not they cease to be exchange control resident, which involves a formal process with the South African Reserve Bank. And that's something they usually discuss with their South African advisors because there are consequences of them doing that. Residence, South Africa's got their residency breaks down sort of to two tests, which is one is a physical presence test, and they've also got a concept of ordinary residence, which is more to do with intention and where you consider your permanent home to be. As you know, we've got the two important concepts for us are residence and domicile. And since 2013, we've had a nice, clear statutory residency test, which is fairly complicated, but it is clear and definitive. So we can advise clients with certainty whether or not they will become UK resident when they move to the UK, and crucially also on what dates they become UK resident. And it's sometimes a factor we have to work with their South African advisors to ascertain whether or not they will also cease to be South African tax resident when they move here. They often will be, but not in all cases. So sometimes covering off both jurisdictions is part of the advice we give. And then our concept of domicile, as you know, it's fairly unique to English law, so there's not a South African equivalent to our concept of domicile. And the easiest way of thinking of domicile is quite an emotional concept of where you consider your permanent home to be. There's some similarities with the South African concept of ordinary residence, but it's also, there are some quirks which are only relevant to the English concept of domicile. And broadly speaking, most South Africans who move to the UK to live will almost certainly become UK resident, but whether or not they become UK domicile very much depends on their intentions when they move here. So if they move here and they decide they're never ever going back to South Africa and they're making the UK their permanent or indefinite home, they're likely to acquire a UK domicile. And if they don't form that intention, then they're likely to retain their South African domicile of origin. And then it's probably helpful to briefly explain what the relevance of those concepts to a person's liability to tax in the UK. So domicile is mainly relevant to a person's liability to UK inheritance tax. And then residence is mainly relevant to a person's liability to income and capital gains tax. And in South Africa, the position is slightly different because in South Africa, it's only residence that you look at. And if you're South African resident, you're going to be liable to tax in South Africa on your worldwide income and gains, and you'll be liable to estate duty in South Africa on your worldwide assets. So those are broadly how the concepts work and how they relate to each other.
That's really helpful. Thanks, Kath. So I guess when we're talking about the tax consequences, I suppose it might be useful to talk about some of the other things that clients should consider before they make the move. And my understanding is that in South Africa, a lot of clients will have a local South African trust that will hold their South African assets and an offshore trust that will hold their non-South African assets. What would the implications be for those structures if either the settlor or the beneficiaries decide to move to the UK?
It's a very good question, and it's one that we're commonly asked when we're advising South Africans. So, as you know, we've got a whole raft of anti-avoidance provisions which can apply to non-UK trusts, and for our purposes, we don't really differentiate between domestic South African trusts and offshore trusts. So the same anti-avoidance rules potentially apply to both of those structures. And they can affect both the settlor's liability to UK taxes and UK resident beneficiaries who receive distributions from those structures. The rules, as you know, are very, very complex, and I won't propose to go into the details of them here. But what a part of our pre-immigration planning for South Africans is looking at their existing structures, how they were funded and when, and advising on the UK tax consequences of the settlor or beneficiaries moving to the UK and receiving distributions. There are also some defences to those anti-avoidance rules which can apply in some circumstances. So we also look at whether any of those defences are available. And lastly, we'll also look at whether there are loans in place. It's very common for South Africans to fund structures by way of loan because there's donations tax of 20% in South Africa. So in order to avoid that, most South African settlors will either sell assets to trustees on loan account or they will loan cash. And depending on, again, the timing of when those loans were made, they can often be quite a useful way of the settlors drawing down on those loans in the UK tax efficiently. So again, we look at the timing of when those loans were made, and we advise on the UK tax consequences of drawing down those loans to fund UK living expenses. So yeah, it's part of the holistic review we'll do of all of a person's affairs before they move to the UK, and it's a very key part of the advice.
Perfect. Thanks, Kath. That's really useful. I think we'll have to leave it there for today, but for anyone contemplating a move to the UK, there is a more detailed guide and some various other briefings and articles on our website, so please do take a look there. If you have any queries or would like to discuss any of the points we've discussed, please do not hesitate to get in touch. Many thanks for listening.